Okay, let's kick off. Well, hello everybody, and welcome to the December edition of our Sprintlaw monthly webinars. This month we'll be talking about legal essentials for marketing your business online. I'm Alex. I'm the co-founder of Sprintlaw. For those of you who don't know us, just a quick introduction to Sprintlaw. We're an online law firm really designed to make legal simple, accessible, affordable for startups and small businesses. Unlike traditional lawyers that charge by the hour, all of our legal services are provided on a fixed fee basis. We operate in many different areas of law, from helping businesses get set up, writing terms and conditions, privacy law, intellectual property law, employment law, contract law, consumer law, which we're talking a little bit about today, and also helping with things like fundraising and so on. We have an optional membership, but about 90% of our clients are signed up to it. There's a free version of it for those of you that want to check it out. And as a Sprintlaw member, you get access to our fairly new platform that has tons of features. You can make your own legal documents, book free calls with lawyers if you're on a paid membership, get credits to spend on legal services throughout the year, and also use some of our tools to manage things like e-signatures, and also to monitor your legal health and let you know when there are changes in laws that might affect your business. So if you're not already a member, do have a look at it and check it out. We've been around for about 8 years now. We have actually closer to 10,000 clients now. It's a little bit outdated. Lots of happy customers. We're founded in Australia, but have now expanded to the UK and New Zealand, and love helping small businesses in general. And if after this webinar you are struck by the inexplicable urge to get some legal help with marketing related legal services, feel free to book a free consult with our team. We'll drop the link in the chat, and we can help with documents or terms and conditions or anything else that you might need. So the agenda for today's session is all about digital marketing and online marketing that may apply to businesses. We'll begin with a bit of an overview of the sort of state of play and the things that one wants to be thinking about when doing digital marketing. We'll then look at the marketing laws, advertising laws, what the key regulations are. We'll then zoom into some more specific areas, how to think about social media marketing, influencer marketing, things you may do with your brand in those domains. We'll talk about privacy laws, regulations, Spam Act for those doing email marketing, intellectual property laws, using other people's IP and protecting your IP online, competitions and promotions that you might want to run, and then at the end, a little bit of a discussion around some new issues with AI in marketing, which is increasingly being used in all sorts of ways, and the various evolving legal risks with doing that stuff. To the extent that you have questions, we have a Q&A feature in Zoom. Do feel free to drop questions along the way. If anything pops into your mind, I don't mind answering as I go. I think it often adds a bit of context to what I'm talking about. We may have a bit of time at the end if there's a lot of questions, but yeah, as I said, do feel free to drop as we go. So let's start by talking about the big picture. For those that have come to these webinars before, you'll recognize this picture that we have on the right of the screen. It's one of my favorite pictures for helping businesses understand how to think about legal and your focus in terms of legal risk in your business. The key point is, and we'll be talking about this in a lot of different scenarios and contexts in this webinar, there are a lot of legal risks that businesses are engaged in or face in their day-to-day operations. And you don't have infinite budget, you don't have infinite time, and you may not have infinite knowledge about what those legal risks are. And so, there may be things I talk about today, or maybe things that you're aware of where you're like, oh, I'm not sure if this one I'm doing might technically breach the law or not. You might not be able to be across every sort of legal risk that there is, and it may be impractical to do so. What you want to be aware of in your business is, what are the big risks? What are the things that are, if I breached this law or infringed this terms and conditions, or breached this contract, where the consequences would be quite severe. I might be fined, I might face criminal penalties, I might be sued by a customer. And how likely are these things to occur? And you want to spend your mental energy and business operational energy on those sorts of things, versus the things that are there's a tiny little bit of legal risk, but even if there was, you might technically be breaching some kind of terms and conditions, but the risks may not be that serious or severe, and it may just be a rectification sort of thing. Um, it may sound counterintuitive to think about that, but equally, one of the things we found with small businesses is that they often can get so um, worried every time they speak to a lawyer that there's so many issues with what they're doing that it just leads to inaction. And it's better to do some things rather than nothing. So as I'm going through some of the issues in this presentation, be thinking about what are the bigger risks for my business to manage, and focus your energy and budget if you have some on those. And as your business grows, you can hopefully cover off more of the square. And certainly by the time, if your business intends to become a larger business, you become larger, you can start to look at the full rectangle. So that's one aspect. The other thing I wanted to mention is in the context of digital marketing, there's two types of laws that we'll be talking about and that you want to be aware of. There are laws and regulation in the sense of things that the government has passed into law or regulators have put in place, which are kind of the rules or the parameters in which your business can operate. For example, as we'll talk about in a moment, if you engage in misleading conduct or you breach the Spam Act or you breach the privacy laws, there is an act of parliament that's been passed that says if a business does X, Y, Z, they're breaking the law, and here are the penalties. They may be fined, or they may have to do X, Y, Z. They may face these penalties. So those are kind of government level laws. But also we have contracts and terms and conditions. These are not laws that were passed by Parliament per se, but if you're using platforms, Meta, LinkedIn, YouTube, and so on, X, these platforms have their own laws, if you will, or terms and conditions that you agree to when you sign up to use them. And if you breach those terms, you're not going to be fined or penalized or breaching the law, but you could be kicked off a platform. And equally, you'll have terms and conditions with your customers and your suppliers that you sign and agree to. And if there's an issue with those contracts and terms, it's not that they're breaking the law and the government will come down on them. It's more that it's a private matter, where there could be liability for various parties. So it's important to understand some of the issues that we'll talk about will be legal issues in the sense of carrying those more severe penalties, and some of them will be terms and conditions issues, which are more, between parties and might just lead to a platform ban and so on and so forth. So I think it's useful to keep that distinction in mind when we're talking about the various issues. So let's now talk about some of these laws and regulations. So the first thing I always like to say when we're talking about digital marketing law is to draw people's attention to the Australian consumer laws and this fairly broad law that we have in Australia about misleading and deceptive conduct. You can see on the slide here, we have this sentence: it's illegal for businesses to engage in conduct that misleads or deceives or is likely to mislead or deceive consumers or other businesses. So this is an Australian law. It's one of the broadest misleading and deceptive conduct regimes that exist in the world. It's broader than what exists in the US, what exists in the UK, and it means that businesses have to be more careful in this jurisdiction than they do in other countries around the way that they present claims. It's a very broad statement. It says businesses cannot engage in conduct that misleads or deceives. The law itself doesn't have comprehensive definitions of what misleading or deceiving is. It's generally understood to be if a reasonable person saw a statement or a piece of marketing or something that you put out as a business and thought it meant something other than it did, then you'll be likely to have issues under this law. And there's tons of cases now that have given examples, and we'll go through a few in a moment. But it's something you want to have in the back of your mind at all times. If you're putting out statements on your website, in your marketing materials, on social media, anywhere, this is kind of the basic litmus test in Australia. Is this misleading or deceptive? Now, there are, of course, claims you might be thinking about where people say, the world's greatest shaving cream or whatever it is, and they have these outrageous claims that they use for marketing purposes. Because their claims like that may be so outrageous, there's law to suggest that the reasonable person knows that's what we call mere puff or just a marketing use of marketing language. So the law is not that strict on obviously satirical or hyperbolic claims that wouldn't actually deceive people. But it is some of that stuff where you've got those false reviews, or you're doing those pricing comparison tables that it can be a little grey if the way you present your business kind of gives the perception that you're better in many ways when you're not. These sorts of things, which a person may actually be deceived by, are where we start to have some issues in marketing. So that's one of the key points. Now, depending on what industry you're in, on top of this general law that applies to everybody about misleading and deceptive conduct, there can be industry-specific regulations. For example, if you are marketing health-related or medical products, and you're making specific claims about medical or therapeutical benefits that aren't backed by reputable studies and so on, there can be specific regulations you may also be in breach of. So depending on which industry you're in, there may be even more restrictions on what you can and can't say. But for pretty much all businesses, this is the thing you want to be having in the back of your mind pretty much all the time. Just to bring out a couple of examples, this is a pretty famous case from a few years ago, Nurofen versus Panadol, and you've got an advertisement here that suggested, with this chart, you can see on the left that Nurofen's basically more effective in treating headaches, and implying this is backed by scientific research. Now, there wasn't much science behind this chart, but the fact they've presented it as a chart, they've got paracetamol there. They haven't named Panadol for various other legal risk purposes, but still, Panadol obviously had a vested interest in paracetamol not being portrayed as objectively worse than Nurofen. So the presentation of this, the fact it looks scientific, even the presence of the fine print and the chart, suggested that there have been some studies showing that Nurofen was clearly scientifically better than paracetamol for common headaches. And you can see the little footnotes up the top there, which suggested there were scientific claims behind it. The federal court said no, that was insufficient to do an ad like this, and they fined Reckitt Benckiser $6 million. So this gives you a bit of a sense of the kind of ad that might be considered misleading. There's a bunch of other cases as well. Duracell and Eveready had a case where Gillette was claiming that the Duracell battery lasted up to 3 times longer. Now, there was a claim as to whether that was truthful or not, and the court actually found that one to be truthful because there was good evidence to back it up. So, it's similar kind of competitors making claims about each other situation, but in this case, it was specific enough and backed up with enough evidence that it got through. So if you can back up the claim, then you can make these kind of statements. There was another one where we had one of those comparison tables, the $49 plan with Optus and Telstra's phone plan. There was a challenge from Telstra saying the way you presented this pricing table is misleading. You've picked specific features to make you look better. There was a lot of arguments. Optus ended up winning because they had taken time to present it fairly. But you can see again how this is an area where, for a lot of businesses, you could end up with issues depending on how you present it. And on the other hand, Optus made claims that its cable service had NBN-like speeds, and it was found that they didn't in fact have NBN-like speeds, and they ended up with some penalties. So it very much turns on whether you can back up the claims that you're making, as you can see. But these are the kinds of scenarios we're talking about. And even though I'm using like large businesses as an example, and it's true that the regulator tends to focus on them, there's plenty of examples of the ACCC, fining smaller businesses for making similar misleading claims. So you want to be thinking about, with your business, the statements that you're making on your site, the way you're presenting your ads, the way you're designing them, particularly when you're engaging in sort of comparison or competitor, marketing. Can you back it up, or are you misleading people in the way that you present it? It can be a fine line. And I should mention, we are talking about marketing, but there's lots of examples in, sales processes as well when businesses are doing one-to-one sales with customers, trying to, convince a customer that their business is great, particularly for services businesses, misleading case studies, false case studies, making up facts around what's happened with prior clients, reviews, people paying for fake Google reviews or Trustpilot reviews, all these sorts of things. There can be issues there with misleading and deceptive conduct, and these are things that sometimes face small businesses. So be careful with all of that stuff. Make sure that if you've got a sales team or when you're engaging new clients, that the wording they're using and the examples they're using are not breaching this misleading and deceptive conduct requirement. Got one question here. One of my competitors suggested that they innovated a technology, however, that was already existing. Is that considered as misleading? Difficult to answer that in the abstract. I think that would very much turn on exactly what they said and exactly what they've done. But it could be. Is probably the answer to that question. If they, depends on what language they used around the word innovated, how different what they created to what was already existing, and whether ultimately they've misled a consumer. Yeah, for sure. I guess I can't really comment on the specific case as to without looking at it. But if it is the case that they have not done anything and it exists broadly on the market and they suggested in some way that it doesn't and it's unique in some way, then that would be a reasonable case for, a misleading and deceptive conduct claim, because a person, if it's looking at this business, is misled into thinking this is unique or original in some way and then is induced to purchase this product. You kind of have these sorts of issues. So that's the misleading and deceptive conduct stuff, which again I think is one thing to sort of have burned in the back of your mind and everything that you're doing in your business. Now let's zoom in a little bit into social media specific marketing laws and influencer marketing laws. Social media has been around now for as a major way that businesses are acquiring customers for more than a decade, 10 to 15 years now. And the law has started to catch up a little bit in terms of regulating the various activities that go on social media. But that said, the pace of change with social media is so fast, the proliferation of content is so fast, and the challenge with enforcing potential legal breaches happening on social media is one that the regulators are still struggling to deal with. And so, oftentimes, and we hear this from clients all the time, and you've probably seen this looking around the internet, you see things going on social media where you think to yourself, surely that's breaching a law, surely they can't do that. And many times you might actually be correct, and it's not that there isn't a legal breach going on, it's just that enforcement hasn't happened. That doesn't mean that what you see online, you should go, well, I'm going to do it too because everyone else is doing it. The future may not resemble the past. Regulators are cracking down. ACCC has been giving increased enforcement powers in the last couple of years. There's more and more laws going up on social media. The platforms themselves are starting to ban people that are using accounts that are inconsistent with their terms and conditions. So there are increasing risks, and it's worth being aware of this stuff. And our advice as lawyers would be to use this technology carefully. Not so carefully that you can't market your business at all, but just being aware of what the legal considerations are. So one of the big issues on social media is sponsored content. So either you might be paying an influencer to market your content, or you might be an influencer who part of your revenue is promoting sponsored content. It needs to be disclosed in general when content's being sponsored. Now, this is just a subset of the misleading and deceptive conduct laws. If somebody looks at sponsored content and doesn't realize it's sponsored, if somebody's saying this product is so amazing, wow, I can't believe how good it is, but there's been some payment or some inducement for them to say something like that, again, you have a case where a consumer is likely misled. And so there's some issues there. There's also increasing guidelines, and now both in terms of industry codes, but in addition, a lot of platforms require it. So and can ban accounts or take down posts if it's not appropriately disclosed. So in general, if you're doing anything in relation to sponsored content, you want to have a message somewhere that's visible, that's clear that it's been sponsored. It doesn't need to be a 20-paragraph legal disclaimer, but it should be clear to the person looking at this, reasonably clear to them that this may have been paid for or sponsored. So something to keep in mind for those of you doing that. The ACCC has some guidelines as well on social media stuff and what's acceptable in terms of influencer marketing and sponsored content. So if you just Google ACCC social media marketing or influencer marketing, there's some really great guidelines for anyone that's engaged in that as well. Another issue that comes up on social media is user-generated content. And that's both content of your customers, but potentially content of your staff and so on that your social media account may distribute or share or encourage people to generate. One thing to be very careful with the user-generated content is there can be a whole host of legal issues around intellectual property, privacy, misleading conduct, of course. So some of the issues, if you're sharing your customers' content or you're using content involving your customers, you want to make sure you've got permission to do so. If a customer generates some content, typically the intellectual property is owned by them. And if they haven't consented to you distributing that content, it could be copyright infringement of some description. Also, the user may not be a legal expert, so maybe they've filmed some other people or filmed some people without their permission and so on. And again, there could be a breach of privacy laws happening there. There could be defamation, a bit more of an extreme example, but if someone is being ridiculed in the video and then you're sharing that or liking it or distributing it, there can be liability. So you just want to be careful with the content, just making sure that anytime you are encouraging people to generate content or sharing user-generated content, is this content misleading or deceptive or not? B, do you have consent and the rights to use it to promote your brand or otherwise? C, are there any sort of privacy issues or other issues in the video that you may want to be aware of? And again, all of these issues could end up with potential liability for your business. So it is an area where we often see issues and complaints. Finally, using licensed music or content in general, for that matter, on social media is another issue. If you are using third-party music that you didn't make, or video content that you didn't make, or even we'll come to this in a bit when we talk about intellectual property in more detail, written content that you didn't create, that content is likely owned by the creator of it, and unless they've given you explicit permission, saying, I give you permission to use my intellectual property, my music, in the promotion of your brand, you may be infringing their intellectual property. Now, you probably will have seen some brands, some users post famous songs on social media. Obviously, there's plenty of TikTok dance videos to famous Taylor Swift songs and so on. But that particular song library, the reason that's possible is because record labels have licensed certain songs to the major social media platforms and allow users, usually when it's not being used commercially, to make content with their music, provided that's attributed, and that's why on a lot of those are now quite common popular songs that are user generated, you can see the name of the song in the corner. It's because the platform knows what the song is, it's attributing it, and it's got a license. It's not a big deal with the big record labels to be able to do that. So that's why you do see it on social media, but that doesn't mean you can do the same with your brand. In general, the simplest thing to do if you're using music with any social media video is just to use royalty-free music. There's plenty of websites out there that I think MusicBed is one, where they just have music that already gives you the right to use it commercially if you pay a fee. and that's often the simplest way around this issue. We do see people trying to promote their business with, famous songs, which generally risk copyright infringement. So do have a think about that before using that content on social media. This is just a snippet from the ACCC guidelines on online reviews. This is an increasing issue, particularly we see with retail and food businesses, because reviews are so important to them. They often will either pay for reviews or pay for people to leave fake reviews. And the ACCC website literally has an example where it says, we consider this misleading, and it's got an example of a hotel chain paying somebody to tweet that they love staying at one of their resorts, but the influencer had never been there, and it's likely to be false, misleading, and deceptive. So do be careful with this review stuff, and make sure that they're independent, and if there's anything that's sponsored, it's quite clear to the person reading it that it was sponsored. So that's a little bit on social media. Moving now to privacy laws as they relate to marketing. In general, if you are going to be marketing to individuals, your customers or people that might have inquired with you or people on your newsletter or whatever it is, you need to have their consent before you use their personal information to send them messages. There's a Spam Act as well, which we'll talk about in a second. But under the Privacy Act in Australia, anytime you're using people's personal information, their name, their email, their phone number, any piece of information that could be used if you looked at it to identify who they are, you generally need their consent to do so. Now, there's a big exception for small businesses. Most small businesses that are doing under 3 million in revenue are exempt from the Privacy Act under what's called the small business exemption. You might think, okay, great, I don't need to comply with the privacy laws. I'm in that bucket. There's a few caveats to that. First of all, if your business deals with sensitive information, health information, or you sell personal information, or fall under a number of other exceptions, you can't rely on that small business get out of jail free card. So lots and lots of small businesses it does apply to. Second of all, there's been talk for the last few years that exemption will be abolished in the next couple of years, and there's some draft regulations already in place to abolish it. So even if you're technically exempt now, you may not be in the future. Thirdly, if your business ever grows past 3 million, unless you've been getting consent from your customers from the early days, it becomes very difficult for you to continue using their information after that point. And fourthly, the Spam Act, which we'll come to in a moment, doesn't have such an exemption and applies to all businesses. And so all of that said, I generally encourage all small businesses to comply with the Privacy Act, even if they might have a technical argument that they fall under an exemption. And it's just best practice and builds trust with customers. And what you want to be doing is putting into place some policies and documentation in terms of how you handle people's personal information. The number one document that we recommend most businesses have is an up-to-date privacy policy. You can put it on your website. It's not just good enough to dump it on your website and go, I've got a privacy policy, I'm all good. You also have to draw people's attention to it when they provide you with their personal information. So you can have your privacy policy, but when they fill out your website inquiry form, you want to be having a sentence there saying, by submitting this form, I agree to the hyperlink privacy policy, or a tick box, I agree to the privacy policy. If when you collect the personal information, you've drawn their attention to your privacy policy, generally now, if the privacy policy says, when we take your personal information, we may use it for A, B, C, D, E, F, G, to market to you, to prepare you a quote, et cetera, et cetera. If they've consented to that, you now have the right to do those things. If they haven't, it's difficult for you to say, oh, it was there in the footer of my website if you never actually drew their attention to it. And again, if you're collecting people's personal information offline, maybe they come to your business and there's like an onboarding form and you collect their name and their details, and you have a privacy policy on your website, which they can't access at the time that they're providing you with their information in person. Again, you're not really complying with the Privacy Act unless you have a printout version of your privacy policy or a shortened version of it, or you could show a hyperlink to it, and if they've got their phone, they can navigate to it perhaps. But you need to take some steps to draw their attention to the policy, and that's one of the big mistakes we see a lot of businesses make. The Privacy Act's also changed. I mentioned there's some changes coming. A bunch of changes also happened in the last 2 years. There's been 2 rounds of major changes to the Australian Privacy Act, including a lot more enforcement power given to the privacy regulator, really like earlier this year and late last year. And we're starting to see more enforcement of privacy breaches. And there's other requirements around disclosing what you might be doing with AI and so on, depending on what your business does. So if you're not on top of your privacy requirements, it's a good time to get on top of it. Globally, the GDPR came out in 2018 in the UK and Europe, which is a very high sort of standard that's applies to businesses in those regions. But if your business operates internationally, you may need to comply with that regime too. And the CCPA in California came out, I think, in 2019 or 2020. Globally, we're seeing a lot more countries move towards more strict privacy laws for businesses, and the new changes coming to the Privacy Act in Australia are really designed to follow those. So the key message here is get on top of your privacy requirements. At minimum, have that privacy policy before you market to your customers. Make sure you're getting their consent to do so. You also should have a contact address where they can contact you for questions. If they ask you to remove their information, with some exceptions, like if you have to maintain it for legal purposes, you can. But generally, you want to be complying with those requests to provide them information about what you're doing with their information and removing it when they request it. So these are the sorts of issues that you want to be aware of when it comes to privacy law. The Spam Act is the other related law, and this is a bit more specific to sort of email marketing and related forms of marketing. And the Spam Act, passed in 2003, has a general statement: it's unlawful to send unsolicited commercial electronic messages with an Australian link without consent. And even if you have consent, those commercial messages must contain contact details and an unsubscribe facility, or a way for somebody to unsubscribe. So in general, you can't contact people when they haven't solicited you to contact them. Now, there are exceptions: express consent and inferred consent. Express consent means they said you could contact them. They've agreed to your privacy policy, for example, and they said, I'm okay for you to contact me about related products and services. And that's how businesses often get the consent required to remarket to their existing customers, send follow-up messages, all those sorts of things. So the privacy policy is really important for your email marketing. Now, inferred consent is the other form of consent, which a lot of businesses rely on for cold emailing. Certainly, if a website publishes a publicly available email address, contact us here at info@xyz, that's often seen as inferred consent because they're inviting you to contact them. So it wouldn't necessarily be an unsolicited commercial electronic message. Again, if there is a message that the person might reasonably expect to receive, and their contact details are available online, that can be a basis for which to do some cold email marketing. But you do have to be careful if you're doing any of that cold email marketing. Now, on LinkedIn, for those of you like me who are on LinkedIn, it can be a minefield for receiving what seem like unsolicited commercial electronic messages. What's actually happened is, when you've accepted LinkedIn's terms and conditions, you've consented to be contacted in the way that LinkedIn allows you to be contacted. So, it's difficult to make a Spam Act breach case for LinkedIn messages, which is why there's so much stuff happening on LinkedIn, and often people taking those conversations off LinkedIn. So LinkedIn can be a real double-edged sword for avoiding that as a business owner, but also it can be a way for those of you that want to do the outreach to make sure you've got some consent if you're using the LinkedIn functionality to contact people. So yes, these are the sorts of issues that one should be aware of in relation to the Spam Act. My advice for anyone who's doing email marketing is make sure first of all, every email that you're sending, unless it's like a transactional email where you're just emailing a client back and forth, any marketing type messages need to have that unsubscribe button or facility or way to unsubscribe. That's really, really important. And if not, you can be reported to the spam regulator, and there can be fines and penalties. And second of all, if you're doing any of that cold emailing, just be careful in terms of, do I have consent to contact this person? Is this a publicly available email? And can I actually send this message? And be very careful if people are unhappy with you contacting them to cease contacting them, because you don't want to be risking breaching these spam laws. So hopefully that's quite clear. Anil's asked, what about an organization such as places of worship? I think that question, not sure what that question is in relation to, potentially privacy law. I might need a bit of clarification on that one. So intellectual property laws are another area to be aware of when you're engaging in digital marketing. What you want to be careful of and protective of is, are you making sure that when you engage in digital marketing, you are complying with people's trademark rights, complying with people's copyright rights, and not undertaking IP infringement. And equally, you want to make sure that your own brand, when you're operating online, is protected, is not being infringed or used by others, and that your content is not being used without your consent. So as a quick 101 on what trademarks and copyright are, trademarks are a registration that you can make to protect your brand name, your business name, your logo, your product names. They are different. Obviously you pick a company name for your company, and you might even register a business name. Those are different to trademarks. Trademarks give you an exclusive right to use a brand, a logo, a phrase, a smell, a color, a bunch of other sorts of specific rights, all usually in a business context around your brand. Exclusive right to use it in a particular country, in a particular industry. So for example, Sprintlaw has a trademark for the word Sprintlaw, for our little S-shaped logo, and that means nobody else in the legal industry can use the word Sprintlaw or anything like our S-shaped logo, or anything similar to Sprintlaw, probably Sprint Legal, Sprint Lawyer, anything like that. They can't use it in the legal industry without our consent, which means we have a pretty strong right to this brand and this goodwill that we're building. Apple, for example, has trademarks for Apple in the technology industry. They couldn't get it in fruits because that would be too broad, and there's laws around what you can register a trademark. But in technology, they have a trademark around Apple. They also have trademarks for their products, MacBook and iPhone and iPod and all those sorts of things. So trademarks are not just about the name of your business, they're also the name of your products, but often you'll trademark the name of your business too. And for those of you that don't already have a trademark for your brand name, if you can get one, if it's not too general or generic, you really want to try and get one, because it's a very powerful protection for your brand. So once you have it, you want to make sure that it's protected and only being used with your consent. And equally, whenever you're doing marketing, you want to make sure you're not using somebody else's trademark without their consent. Now, it can be a fine line, because describing in a social media post a piece of news, did you see that Apple had to recall 600 MacBook Pros because there was an issue with them. That's generally allowed. That's kind of a descriptive use of the term Apple. But if you want to say something like Apple, we are Apple's #1 verified supplier. Now you're using Apple's brand to promote your brand, and you're implying that they've somehow authorized you to do so. That could be a trademark infringement. So something to keep in mind when you're using your customers' brands for case studies, or you're using people that you've worked with to promote your brand, or you're using people's logos. A lot of people put a bunch of logos on their website to make their website look credible. They may not have gotten the consent of that brand to use their logo. These are all trademark issues. So you just want to make sure that you've got consent before you use trademarks. And of course, you're protecting your own trademark, and it's not being used online without your consent. And for those of you that want to check how your trademark's been used, you can just sort of Google search your brand name, or do a reverse image search if it's a logo, and you can often find places that you didn't expect where your brand might be being used, and you can send them cease and desist letters if you have a trademark. So a few issues there with trademarks. Copyright is a another area of law which uh, also comes up a lot in online marketing. I touched on it a little earlier. Copyright's different to trademarks, whereas trademarks are about sort of brands, logos, words. Copyright is legally defined as subsisting or existing in any original work that's recorded in material form. And what we mean by that is things, like music or novels or plays or performances or film. These sorts of things are the domain of copyright. And unlike trademarks, where you go apply for a trademark, you register it in an industry, you get like a trademark registration number, copyright doesn't really have a body that you register it with. Under copyright law, anyone who creates an original work immediately owns it, the author owns it. From the moment of creation, it's theirs, and they have exclusive rights, usually until 70 years after their death. So their estate would have rights up to 70 years after their death. So if you create original stuff or somebody else creates original stuff, you or they will own it for that time period without having to register anything. The only way copyright can move is under a contract where somebody says, I hereby assign my copyright to you. And for those of you that have or have signed employment agreements, that's obviously a very important thing for businesses where they say, oh, okay, I'm paying you, the employee, to do stuff for my business. Any original copyright you create will be transferred immediately to the business if it's done in the course of business. So that's how businesses get their copyright via contract. But if they didn't have that in place, it would technically be owned by the employees or the authors. So that's how copyright works. Now, in this digital marketing context, what we want to think about is, okay, if we are posting stuff on social media, posting blog content, putting together, photos, text, video, film, images of stuff that was created by other people. Unless they have transferred it or consented to you using it, there is a risk that you're infringing their copyright. And we see this happen a lot for our clients. They've done some blog posts. They've used an image that they found on Google. It wasn't a royalty-free image. It wasn't a stock image. It was just something that they found online, and their website starts to do pretty well, and they get contacted. Someone's done a reverse image search and said, hey, that's my photo, you need to pay me money, you're infringing my copyright. Or people are like writing blogs, they've paid a content writer to take bits and pieces from various places. There's some plagiarism, which is not really a legal concept, but copyright infringement will be the legal version of plagiarism going on. And again, cease and desist letters and potential liability there. So and same on social media, people are sharing images, memes, graphics to promote their business, but the person that created it may not have consented to it. So there can be risks again there. And sometimes we see brands sharing something on social media, what they thought was innocently, but to promote their brand, and then they get a cease and desist letter from the creator, or a creator demanding compensation, which sometimes they have to pay. So these are the issues. You just want to be careful whenever you're using copyright in your business. Do you have the right to use it? And if not, it can be a little risky. Now, coming back to what I said at the beginning of this presentation, brands are doing this all the time. They're sharing a meme that someone technically owns the copyright to. Nothing happens. They take the risk, and maybe your business has done that already. And I would just say it's a little bit risky, and if you can avoid it, it's definitely better. And in general, using the stock images or avoiding copyright infringing content or using content that your business has created is much better. So that's my issues there. And again, the inverse is true. If you've got your copyright, your content that you've created, you want to make sure it's protected. You want to make sure people aren't using it without your consent. And if they are, you've got legal rights against them for IP infringement. So that is what I want to say about intellectual property laws. We've got a question here. How can an Australian business take legal action against a Vietnam-based cybersecurity provider if, despite using their services, the business is still hacked and believes the services were inadequate or not performed with reasonable care and skill? That's not really a digital marketing question. That's more of like a contract breach question, and is probably a little specific for me to deal with in this webinar. But I'd encourage you, if that's an issue that is facing your business, to reach out to our team. We can provide some advice on it. There's, in general, I guess I can say, if there's a contract breach, a business, depending on the contract that was signed, can sue the other business for breach of contract for not providing services with care and skill. If they're overseas, it can be more difficult because technically, which court do you sue them in, and so on. But there can be various other ways to deal with that. Meg's asked, what about images created via AI? Who owns the copyright? Great question, and I have a slide on AI coming up, so I might deal with that question there. But to give you a preview of the answer, that is a very unclear question that lawyers are still debating. But yeah, let's come back to that one. Just two more slides to go on these digital marketing law topics. Competitions and promotions is one I just wanted to cover. For those of you who run competitions in your business, you might run a competition online, win a free product, win a free service, etc. Just be aware that there are laws around marketing competitions in Australia. Actually, they are not that simple. Every state and territory has their own laws. And in some states, depending on what kind of competition you're running, you actually might need a permit or you can suffer a fine or a penalty. So if you are going to run a competition as a promotion, two things I recommend. First of all, have a terms and conditions. Otherwise, you can have disputes. You can be accused of misleading conduct, et cetera, et cetera. How does it work? How is it judged? When do people have to apply by? What are they getting specifically? What are the rules of the competition? Which is something Sprintlaw draft up a lot, competition terms and conditions. And the second is consider whether you might need a permit. Now, in general, in competitions, we have these two concepts. You can have game of skill competitions or game of chance competitions, and the laws are different depending. In most states, they adopt the same concept, game of skill, game of chance. I think in all states, in fact. So depending on what kind of game you're running, you may or may not need a permit. If it's a game of skill, you basically usually don't need a permit if the winner is chosen based on merit. So, you would need to have a judging system, a fair judging system that's not misleading. Maybe it's like whoever leaves the best comment, takes the best photo, does the most creative answer, and then you pick a winner based on skill. Then that's generally seen as, it's not like a lottery. It's a competition that you can run, and that's the most straightforward competition to run. If you want to do a full game of chance, we're randomly going to pick a winner from a draw, buy a raffle ticket, or click here to enter, and we'll pick a random winner. In many states, you actually need a permit. Now, if you're running it online, if you're opening up entries to anyone in these states, then these laws will apply to you. So it is something that we see, people breach from time to time and suffer various consequences, being taken down off a platform and occasionally being fined by a regulator. So just make sure when you're running these competitions that ideally you set them up as a game of skill so you can avoid the need for a permit, or if you do really want to do a game of chance, you get the permit. And the permits are not that expensive, so it can be affordable, but again, it varies from state to state. Anil's asked, does privacy rules apply to not-profit organizations such as places of worship? Yes, they do apply to non-profit organizations. There are exemptions for smaller organizations, as I mentioned earlier. So it depends on the size of the not-profit, but certainly they do apply. And there's also extra laws around fundraising and the way the information is collected there as well. So certainly an issue for not-for-profits to be thinking about. So now coming to AI in marketing. People are increasingly using AI in marketing strategies in businesses, and there are, as with the law in general, the law is usually a bit slow to catch up with what's happening in the world and what's happening in the business world. And so I would say in Australia right now, AI is pretty underregulated, but regulation is coming, and we had the first set of really targeted AI laws be passed in the last sort of year with the Privacy Act updates, although those laws were quite targeted at businesses that are using AI to make automated decisions that affect people's rights. So it's not really addressing directly marketing stuff. As it stands today, the existing laws I've already covered around misleading and deceptive conduct, copyright, and so on and so forth are the laws that will apply to AI. So we look at AI activities through the lens of, is this misleading? Is this copyright owned by someone else, et cetera, et cetera. And that works to some extent and should guide your use of AI. Although in other areas, it can be a bit complicated. For example, like the question we just had around, well, is it copyright infringement if I use an AI to generate an image? So to give you a bit of a sense of the legal considerations to be thinking about and what the issues are or are likely to be. First of all, if you're using AI-generated content, whether that's text content or image content, most of the AI platforms will say to you, you can use this content. If you write the prompt, OpenAI, ChatGPT will allow you to use this content for, commercial purposes. So OpenAI doesn't necessarily have a problem, and same with most of the other AI platforms, with you commercializing the content that you create in there. That doesn't mean that you may not be liable. If you generate an image that infringes somebody's trademark or infringes somebody's copyright, if you said, make me an image that looks exactly like, a MacBook in every way with the Apple logo on it, the AI filters often will say, sorry, we can't do that. But if you manage to get one and then you post that on your site, saying, look at our new laptop design that we created, that is likely to still be copyright infringement, even though it was AI generated. So if you generate material that resembles existing works, you can be liable. There's a lot of legal debate going on right now about the fact that a lot of the AI platforms themselves are trained on copyright material for which they didn't get consent. The AI companies are arguing, we just took publicly available stuff and have synthesized it. We haven't infringed any copyright. Whereas the creators of a lot of the works are saying, well, you didn't just browse my website, you ingested it and started doing stuff with it that I didn't consent for you to do, and you've enabled people to infringe it. So I think there's a little bit of unclear where the law will land, but I suspect there'll be more and more liability for AI platforms who are distributing this content. But I think as a user of AI right now, as a business, you just want to be careful that the stuff that you're creating is original. It doesn't resemble existing works. You're not prompting it to look like something that it shouldn't look like. And same for the content. If you are getting it to write blog posts for you, if the content is original, then great. But if you're using an AI to summarize someone else's blog post and reword it, and the AI is using phrases or bits or original information in that blog post, you can still be infringing their copyright even if the AI rewrote it. So you just want to give it some human oversight, make sure it's original, and all these risks I mentioned earlier still apply to the AI content. It can be original if it's generated. The platforms will allow you to use it. But that doesn't absolve you of all liability for a creator seeing it on your website, seeing it associated with your brand. If they say, that's too similar to mine, that's my wording, and you say, I used AI, that's not a defense if you've created something that is clearly infringing, particularly if you do it knowingly. So definitely be cautious. I'm not saying don't use it, but I'm saying just be cautious with it. AI tools can trigger Privacy and Spam Act obligations. There's more and more AI being used in personalized outreach. We're using some of that at Sprintlaw in the way that we're marketing with our clients. But you just need to make sure that if you are using AI tools to write personalized emails or you're feeding customer data into AI systems, you want to make sure that you've got consent. It can be in your terms and conditions, it can be in your privacy policy to do so. And of course, if you're sending AI-generated outreach emails, which is becoming more and more popular right now, you want to make sure you've still got at least that inferred consent to contact them, ideally explicit consent, and you're not sending emails after somebody wants to unsubscribe. So there's a lot more of that personalized content going out. And we had a good question here from Anil. To generate AI, we need a prompt. The prompt is user generated. Who owns copyright in this case? Yeah, that's an interesting one. Hasn't been tested that much in court, but I think the consensus from most lawyers would be if you created an original prompt that is, capable of producing unique content, then the prompt itself may be copyrightable. Now, if you've created a unique prompt, but the thing that AI spits out is infringing some copyright, you can't say, "Oh, my prompt was unique," because if the output, like I said before, is just like a picture of if you found a very creative way of telling AI to make, a design that, looks like X, Y, and Z, and then when it spits it out, it looks exactly like a well-known product or something that exists, and you can't get around it by saying, well, look at this prompt I used, I didn't even reference it. So the prompt itself may be original, but if the output of the prompt generates infringing material, it could be infringing. And yeah, Neil, you've noted the same prompt will not generate unique output. Yeah, that's of course true. Every time you prompt the AI, it may come up with a different output, and sometimes it might produce non-infringing output, and sometimes it might produce infringing output. If you think of a blog post prompt, you could get an AI to produce a ton of blog posts for you. Some of them might be fine, but if some of them contain work that's been taken from somewhere else, or wording or phrases or concepts that are protected by someone else, it could therefore be infringing. So these are the sorts of issues that can arise when you're using those AI tools. And finally, AI claims individuals must not mislead consumers. I think everyone knows that the large language models now, can often hallucinate, make things up, fill in the blanks, generate very easily fake case studies, exaggerated testimonials, exaggerated benefits, and people are using it to spit out content very, very quickly. The result of this is you might end up, without realizing, with content that you've published which contains errors, which again might breach those laws I mentioned earlier around false, misleading, or deceptive conduct. So it's risky to be putting out AI content that you haven't fact checked. It can be legally risky, particularly given this broad misleading and deceptive conduct law that we have. In my industry, in the legal industry, there's been a proliferation in the last 6 to 12 months of lawyers showing up in court with legal arguments that have made up cases and made up legislation, the courts, one of the courts has put out a kind of practice note, essentially requiring lawyers to not use AI in this way, and has in fact, I think, struck off a few lawyers for not fact checking AI outputs. So that's specific to the legal industry, but you can see that laws around fact checking AI outputs might become more applicable to businesses, particularly as more and more businesses can generate a lot of information about themselves, and it's a lot easier to, whether advertently or inadvertently, say misleading things about your business if you're producing it quickly. This law still applies. It still applies to the AI content. So just be very careful with what you post, and make sure what you're saying there is not false, misleading, or deceptive. So that brings us to the end of the presentation. I hope people enjoyed it and found it useful. As I mentioned, if you do have any questions about digital marketing or anything else legal, do feel free to reach out to our team. Otherwise, we do these every month, so we'll pick this up again in the new year. In the meantime, wishing you all the best for the holiday season, and thanks so much for coming, and I'll see you next time.